So Tied House law started in the United Kingdom. So basically what they called their pubs was a tied house, because normally they would have one supplier who supplied a particular brewery or pub, and they were tied together so that that pub couldn't buy alcohol, whether it was beer or spirits, from any other supplier other than the one it was tied to. And that's where the term tied house comes from. And then in the late 19th and 20th centuries, bars in the US were often tied houses with exclusive brewery contracts. And the supply arrangements led to fierce competition among retailers. They lowered the prices to gain market share, and it led to excessive consumption because they were really over promoting the alcohol. And that's what really led to prohibition, because people were drinking too much. Too much money was going into these tied house situations, and it was really tied to the Italian mafia, which is, you know, the whole Al Capone deal and bootlegging and all of that. And so alcohol was really tied to organized crime, and that's what led to prohibition in 1919. And then so in 1933, prohibition was repealed, but alcohol remained heavily regulated throughout the US with the passage of the 21st Amendment, which was allowed them to sell alcohol again. And the laws were implemented for two reasons. One, to minimize excessive sales and consumption from over-aggressive marketing programs. And that's, I guess, the reason. And though the laws vary from state to state, the overall goal of tied house law is to limit the ability of large companies to dominate local markets through vertical and horizontal integration, and to minimize excessive sales and consumption from over-aggressive marketing programs. Anyway, I wrote that wrong. But, you know, basically when they enacted the 21st Amendment and they created the tied house laws, they were trying to prevent the kind of organized crime and overconsumption that was happening before they instituted prohibition. So separating out, you know, the three-tiered system and making the licensing requirements for each one of those relatively difficult was how they controlled that process. And tied house laws evolved since 1933, but many of the regulations still exist as they were written. A lot of them still exist the way that they are written. They have loosened it up, as you know, to allow for some direct-to-consumer sales, but for the most part, it really is still the 1933 laws. And a lot of people feel that that should be changed. But so far, we're not getting very far with that. It's a very slow process. And so I think we all know what the three-tiered system is. If you're a producer, you know that what a wholesaler and a retailer are, and that they have specific licensing requirements that are different from yours. The basic structure of the system is that producers can sell their products only to wholesale distributors who can then sell to retailers, which actually isn't the case in every state anymore. There are ways to get around that. But fundamentally on the national level, that is still how it's set up. And retailers sell to consumers. Producers include brewers, winemakers, distillers, and importers. Some states chose to become alcoholic beverage control jurisdictions. Actually, a lot of them did, although that is changing and it's skewing away from that. But there are still some states, it used to be the case in Washington, where you could only buy spirits, particularly in a government-run store. And they basically controlled the process so that they weren't going to allow private companies to be the retailers. Or it was contractors rather than by private entities. And who regulates tied house law? Tied house law is regulated by the Alcohol, Tobacco, and Tax Trade Bureau, or the TTB. The TTB was created in January of 2003 when the Bureau of Alcohol, Tobacco, and Firearms was extensively reorganized under the provisions of the Homeland Security Act of 2002. The act called, the act called for the tax collection functions to remain with the Department of the Treasury, and the TTB was born. So basically, the regulatory body of the TTB is more about tax collection than it is about regulation, but they have a division within their department that's called the FAA. And they are the ones that actually enforce the tied house laws and the regulatory practices on a federal level. States have their own, but for the federal program, it's the TTB and the FAA. And they do have the regulatory power to file criminal charges for any violations of the law, get injunctions or consent decrees, and revoke and suspend permits. What I have seen in the past in terms of tied house law and the way that they regulate it, especially on the federal level, if someone violates the law, it depends on especially what they do. And if it's a marketing violation, it's generally just a warning. But I have seen license suspensions, and usually what they'll do is they'll do a 6-month suspension if somebody persists in violating whatever law they were violating. I haven't seen a lot of fines, but it does happen, and it is important to know about this stuff. These are the tied house laws, which are the actual laws. This is the laws the way that they're written, and these are a division of all of the laws that are wrapped up in alcohol regulatory processes. These are the specifically tied house laws. And I'm not going to go through them and read all of this, but really, as it applies to marketing, the most important thing is that that a supplier or a producer cannot give a retailer a thing of value. And that can be lending money, offering free product, anything like that. You can't, because they consider it an inducement to favorably promote your product over other people's products, and that's not what they want. So how do the laws apply to wineries? For small producers who sell most of their products direct to consumer, the biggest impact of tied house law falls on marketing. The fundamental principle of tied house law is that there can be no inducement of a retailer by a winery to sell their product to the exclusion of other products. Therefore, a producer may not offer a retailer anything of value because it could influence the retailer to give preferential treatment to that producer. The TTB considers marketing, including social media, websites, and email promotions, a thing of value. So if a restaurant or retailer is carrying your product, you may not promote them on social media, your website, your marketing materials, or in an email campaign. And there are some exceptions to this, and the exceptions do to some degree vary by state. But I did look up the laws, and I didn't look in all 50 states, but I did look in sort of the big wine areas, which would be California, Oregon, Washington, New York, Florida. And the recent legislation is skewing towards allowing producers to list where their wine is served, like a restaurant or at a retailer. You can't say anything nice about them, but you can say it's there. And if someone asks you, then you can always tell them where to find your wine in another state or outside of your winery, but you can't say anything nice about them. So these are the things that you can include if you are having an educational event, like a winemaker dinner, or if you're pouring in a wine bar, you can say the name and address of the place that you'll be pouring or having the dinner, but it can't be too prominent. The names of the wines being poured, the date, time, and location, and other information about the event, but you can't include the price of the wine or complimentary statements about the retailer or restaurant. So I think that when you are doing a winemaker dinner, or if you're pouring and you want to promote this, that you really have to heavily partner with the retailer that you're working with, and you have to ask them to do a lot of the promotion. And that's really what the TTB wants to see, is that if you're partnering with a restaurant or a retailer, that really the burden of marketing should fall on the retailer and not on the producer. You can talk about it on a limited level, but you can't be complimentary. You can't say, this is a great chef, or the restaurant is great. They even go so far as to say that you can't show pictures of the restaurant or retail location, and you can't list the URL of their website. So it seems very limiting to me, but that is the law. So obviously tied house laws are confusing and even infuriating to some producer, but it's not worth the risk of being fined or losing your license. As long as you follow some basic guidelines, you should not be at risk. If you can answer these basic questions, you should be okay. And the questions that you need to ask yourself: is a specific retailer named in your post? If so, is it in the context of an educational event? If not, you have most likely violated the Tied House law. The other question is, does this post provide value to a specific retailer? If so, you have most likely violated Tied House law. So as long as you're following those two basic guidelines, you should be okay. Really focus on making sure that whoever's carrying your wine, or if you're hosting an event, making sure that that person is aware that the burden of marketing does fall on them. But as an aside, with the Craft Wine Association, since we are neither a retailer or a producer, when our members do have events that happen offsite in retail or restaurant locations, we actually can promote it for you. So if you're having a winemaker dinner and you feel like you're in a situation where you want to promote it, but you don't feel like you can, we actually can on your behalf without any consequence, because we don't make wine and we don't sell it. Teresa sells it for us. So there are variations in the Tied House law, as I was saying before. It does vary from state to state, but promoting educational events, pouring winemaker dinners, they exist in some form in most states. They almost always include stipulations that you can't compliment the retailer. One example from Oregon's OLCC guidelines is their products apart from a retailer's. A specific retailer may not be mentioned. A supplier may make lists of retailers. Can you guys hear me? Okay, it's telling me my internet is unstable. A supplier may make lists of retailers that sell its products available to customers. Retailer lists may not include prices and must include every retailer that sells the supplier's products. And then basically they're just a list of other laws. And then the advertising may list no more than the retailer's name and address, the date of the event, and the name of the supplier's product. So no website, no pictures, nothing. So here are a couple of other best practices in wine marketing that are not necessarily Tied House law, but these are other regulations that impact the way that you can market your product. And just to go through them really quickly, obviously you're not allowed to make any statement that is false or untrue that regarding alcohol. You can't say anything disparaging about one of your competitors, another winery, a distillery or a brewery, even no other producer. Nothing obscene, obviously. And I think that there are some wineries that push the envelope with this because, hiring influencers that are out in vineyards and bathing suits, I don't know. But I think that pushes the envelope. You can't guarantee the product. You can't offer a money back guarantee that someone's gonna like it. You can't do anything. You can't say that wine contains distilled spirits if it doesn't. You can't compare it to distilled spirits. You have to make sure that anytime you're talking about your product that it's consistent with what you have on the label, and you can't generalize about your wine. You have to make sure that whatever you're saying about a specific product reflects that specific product. You can't just generalize about the wine. You can't say anything about health. You can't say that, and that it extrapolates onto, you can't say that wine makes you feel good. You can't say that wine will put you in a better mood. You can't say that wine is good for your heart. You can't say anything like that at all, or that it makes you prettier, or that it makes your wife prettier, or anything. Can't do it. And this is the 2 or more different brands or lots of wine shall not be advertised in one advertisement, which means that's the you can't generalize rule, that you can't generalize about your wine and say, our wine is generally 17% alcohol. You have to be specific. You're not allowed to use subliminal advertising. I'm not really sure who's doing that, but can't do it. So what are the next steps, Tied House law? And what can you as a producer do about the fact that you're so limited in the way that you can market your product when it comes to retail outlets? And so, I mean, you go the same route that you go when you want any law changed, is you can contact your state and federal elected officials and let them know how this hurts your business. Sometimes you're going to want to contact people who are outside of your district who sponsor a lot of wine legislation. In California, there are two, Mark Levine out of Marin, and I can't remember her name, Cecilia something, that's out of Sacramento, and they both are very wine friendly, and they push a lot of legislation to try and roll back some of these tied house laws. I'm not sure who the regulators are in Oregon, but I know the Oregon Wine Board is a big lobbying group, and you can always contact your local associations or organizations and ask them to address these policies. There are also national lobbying groups that you can join, and they basically take your membership dues and they apply it to trying to get the laws changed in Congress. You can start a petition and submit that to your local senator or congressman, and try to raise awareness among the people who follow you that these laws are very limiting and that they make it difficult for small businesses to sell their products. And I think that if more consumers knew how complicated it was for small business, for small wineries to sell their products, and how that really hinders your ability to effectively run a business, I think that there would be more public outcry and it would be easier to get these laws changed. And now I'm going to open it up for any questions. Nobody has any questions? Can you guys hear me okay? Okay. Okay.
Your connection was a little wonky. That's why it was going in and out, but overall it was good. Good connection. Good enough.
Sorry about that.
We can't control it.
Yeah. Okay, I'm going to turn this off. Alrighty. So nobody has any questions?
I have none.
Alrighty. Well, we are going to make this presentation. This one actually is recording. I'm sorry, Teresa.
You're good.
Did I lose you?
Good. No, you're good. You're good.
Uh-oh. Did we lose Jen?
I'm here. Can you hear me?
Yep. And that's
Okay.
my question is, can we get the presentation, or if you're recording, how do we
Yes.
access?
Yeah, this one actually is recording. So last week we had a little bit of an issue with that, but this should be good. I can see it. It's right there, the little red light. So.
And you'll send us a link?
I will. I definitely will. We're gonna have
Awesome.
our media guy is gonna make it pretty, and then we're gonna put it up on the Small Matters, and everybody will get a link to it. So,
Hey, Jen.
hi, Chris.
Hi. I'm very new to all this. I mean, we've been up and running for a while, but the whole advertising and social media thing is new to us, and I feel like I'm doing everything wrong. So I was wondering, if we go to a restaurant and visit there, can we post about that and show a picture and say thank you for having us, something like that, or no? Or I mean, like, thank you for showcasing the wine. Not if they carry our wine?
Nope.
Okay. All right.
On the other hand, I understand what they can do is they can do that post.
They
Okay.
can do it. You can say, hey, we came into your restaurant. Here's a great picture we took. Can you post this on your social media? We just want to give you a shout out, but you can't do it yourself.
Gotcha. Well, yeah.
And sometimes that's why I think, we were talking earlier, when people, why this attendance here today probably isn't as big as it should be, is because people don't understand that. And so it's important. Sometimes you have to tell the restaurant, this is why I can't do it. We would be happy to do it, but
Gotcha.
this is why I can't.
Okay. Thank you for clarifying.
Yeah. And a lot of restaurants don't really even know what the restrictions are. So it's not, it's pretty widely unknown that these things are a problem, and that's why people get into trouble. And I hope that, you know, the people who are regulating this over at the FAA and the TTB are understanding, and they're not trying to fine people, and they're not trying to suspend licenses. And if you make a small mistake on social media, I don't think that that's going to have a huge impact for you. At best, I think they might contact you and say, don't do that again. But, you know, unless you are persistently violating the rules, I don't think you're going to be in any trouble. Do we have any more questions? I'm going to go ahead. Can you guys hear me? Okay. Alrighty, well, especially since this is a little bit unstable in terms of my internet, I think I'm gonna go ahead and close it out, and then I will make it available to everybody probably by the beginning of next week.
Thank you, Jennifer. Happy 4th of July to you.
You too. Thanks for coming.
Thanks. Absolutely.
Alrighty. All right. Take care.